So you got hurt at work. Your employer says, it's not my fault you got hurt at work. It was just an accident. So you don't get workers' compensation benefits. Is that how it works? No, not generally. You're in California, you're an injured worker, you have a workers' comp case, and you don't have an attorney. Here's a short discussion of issues that come up. Oftentimes, I talk to employers or have situations presented to me where an employee gets hurt at work, but it's purely an accident, or maybe even the employee did something that they shouldn't have done, ends up getting injured. Is that really workers' comp? Most of the time, yeah, it's still workers' comp. The real question is it AOE, COE in the language that we use? Is it arising out of employment? And is it in the course of employment? So is it AOE, arising out of employment, COE, course of employment? So you work at a fast food restaurant. The fast food restaurant owner has the ice machine worked on. The employee that's doing the work on the ice machine doesn't quite tighten it down properly. There's a hose that leaks. You come around the corner, you slip on water. You fall down, you injure your back. The owner of the restaurant, your boss, says, it's not my fault you fell down. The water leaked. I hired someone to do work and they did something wrong. It's not my fault. It doesn't matter. The injury occurred in the course of employment. It arose out of the employment. You were there doing a job for your employer. It's going to be workers' comp. So that type of thing happens. Maybe, let's say, you're working in a fast food restaurant. You're standing there innocent enough. Another employee picks up a big tray of hamburger buns, turns around too fast because they're not paying attention, and knocks you down. The employer says, it's not my fault. Billy ran into you. Dumb Billy should have been paying more attention. But it's not my fault. Yeah, it's still workers' compensation. The injury arose in the employment. It was in the course of the employment. It's still workers' comp. Let's say, injured worker, you screw up. You need to cut lettuce at your restaurant job and you reach down to pick up the knife and you're not paying attention, or someone talks to you and you're talking to them and you pick up the wrong end of the knife and you cut your hand. Is that workers' comp? Yeah, it's still workers' comp. You got hurt at work. It was arising out of employment and in the course of employment. Now, there's lots of exceptions that can take place. Alcohol intoxication, that type of thing, that may be exceptions. Maybe there's other issues that come up if another person caused the injury, that there may be some third-party liability. But the bottom line is, if the injury arose out of the employment and occurred in the course of employment, the injured worker is generally going to get workers' compensation benefits. Doesn't matter if it was a freak accident, if it was someone else's fault, if the injured worker should have been paying more attention, a coworker should have paid more attention, it's going to end up being workers' comp. Needless to say, it's a very fact-dependent discussion. Every case is very unique and very different. So every case, different fact pattern, going to have the law applied to it differently. But this is a general discussion on AOE, COE. If you found the video helpful, hit the like button down below. And if you have a question on the content, drop a comment down below as well.